Lord, my father purchased the property in the year 95 by a sale deed. And then, my Lord, he gifts the property in my favor on 6/6/2007. Lord, suit Lord,
That whether it is from the joint family proceeds or what, it is a matter of evidence.
Lord, nowhere in the
What is the injunction? Not to
intention is
alienate.
not to alienate.
Then there is nothing wrong with that order.
And just respondents 1 and 2, Lord, filed the suit for partition. Lord, in respect of joint family properties as well as my self-acquired properties. Lord, I filed an application to vacate the injunction. Lord, that is rejected. Therefore, Lord, I am before
What
this
is
court.
no? What happened to the suit?
Suit is, Lord, still in the stage of evidence of PW1, that is the,
Yes, let's see.
please. Just take, Lord, to.
Notices are served.
Sir remained absent, Lord.
Let's see.
May I take the, Lord, may kindly come to the reasonings at page number 14, Lord, point number 1.
Who are you? You're
And the second defendant, Lord, my father purchased the property in the year 95 by a sale deed. And then, my Lord, he gift the property in my favor on 6/6/2007. Lord, suit is filed in 2017 after 10 years challenging my gift deed and claiming partition, general partition. But my claim is only insofar as item number 4.
the joint family property. Then the father, how can he execute a gift?
It is not the joint family property, Lord.
That has to be decided by the trial.
Lord, it is not the joint family. It is purchased by a sale deed.
No.
I'll place the sale deed. That's what, Lord, I.
That whether it is from the joint family proceeds or what, it is a matter of evidence.
Lord, nowhere in the plain they say that it is purchased out of joint family property. What they say is my father purchased the property. Nowhere they say it is the joint family.
For that, an evidence is required for court has to complete.
But still, Lord,
that.
after
What is
10
the
years,
injunction? What is the injunction? Not to
intention is
alienate.
not to alienate.
Then there is nothing wrong with that order.
And just take, my Lord, to the page number 15, Lord,
Yes.
page 15.
Yes.
Lord, 7th line.
Yes.
The plaintiff specifically contended that their father purchased item. This is important, Lord. Their father purchased item number 4, that is 114 measuring 4 acres through registered sale deed. But defendant number 2, by way of fraud, got
So
executed.
all those issues will come in the trial, whether it is how it has been done, whether it is a.
Lord, it is
But-
not pleaded
but
by
it is-
them, Lord.
It is not your self-acquired property.
Lord, the property is gifted to me.
Gifted. That's what I'm saying. You are not. That is not your self-acquired property.
It
That
is
your
not my
father's property.
self-acquired
It
property.
is your
Lord, I
father's
was
property.
taking care of my father. He gifts my
They have sought a relief to that the gift deed is not binding on them.
Yes, they say.
All that have to be decided. Now, if you alienate the property unnecessarily, third-party rights will accrue.
Lord,
I can
am-
understand if an injunction, something, some other order is. No, but as far as alienation is concerned, unless and until the suit is finalized, you can't alienate the property.
Lord, the court says that it may, Lord, I'll just take, my Lord, to
Please read.
the plaintiff specifically contended that their father purchased item number 4, a survey number 114, measuring 4 acres through registered sale deed dated 23/3/95. The defendant number 2, by way of fraud, got executed gift deed through the gift deed dated 6/6/2007. Lord, suit is filed in the year 2017. Plaintiffs pleaded they have share in the suit scheduled properties. Therefore, they sought for partition. My Lord, please come to the next page, page 16, my Lord. Last 10 days, 10 lines, my Lord. Though plaintiffs challenged the gift deed dated 6/6/2007, after the lapse of 10 years. the
Exactly,
plaintiffs-
that's what I said is the finding of the court. At page number, internal page number 7 of the order, middle.
Please,
Further, it revealed to note that, relevant to note that, the question that whether acquired property by father of plaintiff and defendant number 2 is a self-acquired property or it was purchased out of the income of the joint family property is to be decided.
please. Lord, this is the inference of the court, Lord. It is not pleaded by the plaintiffs. Plaintiffs have never said in the plaint that it is purchased out of joint family.
When a plea that it's a joint family property, then it means that.
Lord, they must have at least one word. I would have understood, Lord, at least one word stating that it is purchased out of joint family income. Nothing is there.
Prime officer cases, that's your father's property.
Father's property. My Lord, he gifts the property in the year 2007. Suit is filed after 10 years, knowing fully well that she is in possession. She has made huge.
Now, the purpose of filing the suit itself will be frustrated if this order
Lord,
is not
other
granted.
properties, my Lord, there are 6 items. Their share can be worked out in the other properties in the same survey number. I am just claiming only portion of the.
Provided if they are able to prove that out of the joint family proceeds, your father had purchased this property, then what will happen?
Lord, it is their case that my father purchased the property. Nowhere they say it is purchased out of joint family income.
Let's not be so technical. Please come.
Lord, at least a direction to dispose, Lord, 7 years
Yes,
old, matter.
17,
7
yes.
years.
The agreed by the orders passed in I number 3, invoice number 41 of 2017 dated 1st July 2022. The defendant number 2 is before this court. The respondents herein had filed a suit for partition and also a declaration that the gift deed dated
Lord, gift deed dated 6/6/2007.
6/6/2007 is not binding on the plaintiffs. It is the case of the plaintiff that the suit scheduled property is a joint family property. And as far as item number 4 and 5 of the plain scheduled property is concerned, that's purchased by the father, and the defendant number 2 had fraudulently had got a gift deed in his favor. And according to them, it's a joint family property. Initially, the court had granted the injunction restraining the defendant not to alienate. And IA number 3 is filed by the defendant number 2 to vacate the order passed by vacate the injunction order granted by the court. The court by order impugned had dismissed the said application. Learned counsel appearing for the appellant defendant number 2 submits that the property, it is never the case of the plaintiff that out of the joint family proceeds, the father had purchased this property. Even according to them, this property is purchased by the father by way of a registered sale deed dated 23/3/1995, which was gifted to the defendant number 2 in the year 2007. And the suit is filed in the year 2017. Learned counsel submits that in fact the said relief they sought is also barred by limitation. Further, the trial court had come to the conclusion that that the father might have purchased the property from the joint family proceeds. He submits that that is not the plea of the plaintiff himself, and there was no occasion for the court to give such a finding. And the trial court, beyond the pleadings, had granted the injunction restraining the defendant number 2 from alienating the property. He submits that he has been in possession of the property right from the year 2007 when the injunction was granted. It is submitted that the balance of convenience is more in favor of the defendant than in the favor of the plaintiff. It is submitted that the court below ought not to have passed, ought not to have dismissed, ought to have allowed I number 3 and ought to have vacated the interim order granted, injunction granted in favor of the in favor of the plaintiff and against defendant number 2. Anything to be added? What about the respondents?
Lord, they are served and remained absent.
The next para, the respondents are served, but there is no vakalat is filed on their behalf. Next para, having heard the learned counsel for the appellant, peruse the entire material on record. The case of the plaintiffs that all the suit scheduled properties are joint family properties, and particularly suits to the property number 4 and 5 are purchased by their father, and fraudulently the defendant number 2 had got a gift deed in his favor, and they also sought a declaration to set aside to a declaration that the said gift deed is not binding on them. It is contended before this court that it is nobody's plea that it's a joint family property, and according to the plaintiffs also, it is purchased by their father in the year 1995, and he has gifted it in the year 2007. When he had purchased the property, that is his, he has every right to give the property. The argument of the learned counsel has no force and has no legs to stand for the reason. It is assertion of the plaintiff, and it's their pleading that the properties are the joint family properties, and the father, the defendant fraudulently got a gift deed in his favor. When the contention of the counsel for the appellant is that there should have been unless and until there is a pleading that the property is purchased from the joint family proceeds, they are not entitled for such a relief. Even that contention has also no legs to stand. Looking at the case of the plaintiff, when they are pleading that all the properties or joint family properties. Now, by way of a full-fledged trial, unless and until it is decided that the property is purchased by the father independently, and the said gift deed that is executed in favor of the defendant is valid till such time if the defendant sells the property, alienates the property, and creates a third-party rights, the relief that is sought in the suit itself will be frustrated. Considering all these aspects, the trial court had rightly granted injunction restraining the defendant from alienating the property. In the considered opinion of this court, the trial court was perfect. The order passed by the trial court is perfectly legal and valid, and no grounds are made out seeking interference with the said order passed by the trial court. Next one. This is a suit of the year 2017. Considering the same, this court deems it appropriate to direct the trial court to dispose of the matter as expeditiously as possible, but not later than 1 year.
Right.